Thank you, Jonathan. I promise I'll be very, very quick. This is paper number 15, or presentation number 15. I think everybody should be awarded a certificate of endurance or something, you know, like when you eat 3 steaks in one of these places by a motorway. I just really want to, it's a very, very simple and straightforward paper. I just want to outline the principal contents of the new Protection of the Environment through Criminal Law Directive, the PECL Directive, and to give you a little bit of the background to its adoption, because the background to its adoption and the issue of its legal basis actually, has dictated what this measure looks like and how it might be applied and what its impacts might actually be. If I start with just looking at the background, the traditional view at community law, the adoption of the PECL directive is actually very, very, very significant from a broader, for a broader understanding of community law, because this marks a move by the community and the community institutions into the area of criminal law. This is a new departure, a whole new area of competence, a whole new area of responsibility, if you like, that the community have taken upon itself, not uncontroversially. So in November 2008, this directive was finally adopted and has to be transposed in national law by December 2010. The traditional view was that there was no community competence in respect of criminal law generally, and of course environmental crime as an area of that. The Commission, however, has for some time harboured ambitions, if you like, to introduce common minimum standards in respect of environmental crime. And this comes out of a number of policy statements. These minimum standards generally relate to 2 things. The identification of offences. What conduct should, as a minimum, constitute a crime in the law of member states? And then secondly, penalties. So, minimum and maximum thresholds of penalties for various types of crimes. Now, despite the Commission's sort of ambitions or intentions in this area, it was very clear that the member states really didn't feel that the Commission had, or that the community institutions had this competence. One place we can look for examples of that is that in the subsequent amendments to the Treaty of Rome, by virtue of the Treaty on European Union or Maastricht, the Treaties of Amsterdam and Nice, etc., the member states went out of their way to seek assurances that the community did not have competence to legislate for criminal law, and sought those assurances. So that was always quite clear. However, even as far back as 1992, there's a very interesting statement by Advocate General Jacobs in the European Court of Justice, suggesting that the community might, on the basis of the treaty, have implied powers to adopt criminal measures or to harmonise national criminal measures, where this was essential to achieve other policy objectives, of which, of course, which environmental protection would be one. Now, even when we take this traditional view, the community law was not of no relevance to national criminal law. It still, in a number of ways, was relevant for the exercise of, or the adoption and application of criminal law at the national level. A couple of examples would be in respect of the fundamental freedoms, free movement of persons, free movement of goods, etc., that in respect of fundamental freedoms, if we think of the Scanavi case, which dealt with German, very, very, very strict and very punitive German criminal rules in respect of driving, that you had to change your licence, I think it was within 6 months in Germany, into a German driving licence if you came from another EU member state. If you didn't, you were guilty of the crime of driving without a licence. That meant you were not insured, etc., etc. And so very heavy criminal penalties could be imposed on you. And in this case, Scanavi, about a Greek national, they referred this to the ECJ, and the ECJ said that this interfered with free movement of persons. So criminal law could interfere with fundamental freedoms. For example, also the principle of equivalence developed by the European Court of Justice. And this basically states that penalties introduced by member states to ensure compliance with community law must be comparable to analogous or similar penalties for breaches of national law, so that there had to be some sort of comparability between these levels of penalties. So it wasn't of no relevance. Since 1992, Title VI of the Treaty on European Union, or the Maastricht Treaty, as amended, and these powers were sort of increased gradually through the amendments on the Treaty of Amsterdam and the Treaty of Nice. But since 1992, there has been a provision for intergovernmental cooperation in respect of a broad range of criminal matters. Now, it doesn't specifically mention the area of environment, but there is this broad possibility of intergovernmental cooperation without prejudice to the scope of the EC Treaty. And this is set down particularly in Article 47, and this is very important. We'll come back to that. But what do I mean by intergovernmental cooperation? Basically, this is outside of the community legal order, outside of the first pillar, the European Community pillar of the European Union. So this comes under the third pillar. Now that requires, in the Council, that requires the Member States to act on the basis of unanimity. It doesn't create a directive or a regulation, this legislation that we're familiar with. It creates a framework decision. And a framework decision is really nothing more than an agreement under international law. So it's very limited in terms of its enforceability. You have this unanimous process of the requirement of unanimity in the Council. It's something quite different. And it's much more difficult to enforce, than a directive or a regulation under European Community law, first pillar rules. So that always existed, or at least since 1992, under the Title VI, which was on police and judicial cooperation. The first move in this area, again, I stated without prejudice to the scope of the EC Treaty. In other words, that this third pillar power should not be used to encroach upon the responsibilities of the community institutions under the first pillar, under what we call European Community law. And we'll see that that was the basis of a decision of the European Court of Justice, which actually handed the community institutions the power, at least half the power. You'll know what I mean in a moment by that. Half the power to adopt criminal law. The first sort of development in this area was the adoption by the Council of Europe. Nothing at all to do with the European Community, except that all of the members of the European Union, I should say, are members of the Council of Europe, but it's a much broader international regional organisation. But they adopted a convention, a treaty, on the protection of the environment through criminal law, the CPECL. Now, this was basically a treaty, an instrument of international law, nothing really whatsoever to do with European Community law. And the key element that it included was a common understanding of what conduct should constitute an offence, what conduct as a minimum ought to constitute an offence. So that sets the ball rolling, if you like, in relation to identifying what as a minimum ought to be environmental crimes. The measure never entered into force. It received only one ratification, but it is influential because it started this sort of iterative process of the development of the idea of environmental crime. The next development was in 2000. Trying to move things along, the Danish government introduced a proposal for a third pillar framework decision for one of these EU measures taken at the intergovernmental level. And this proposal, if you like, complemented the convention, the Council of Europe Convention. It added more detail for the European Community or European Union member states. It added a great deal more detail. The convention was very much an outline instrument, a framework instrument. So this added a great deal more detail. And it also required member states to actually ratify the Council of Europe Convention. So it just sort of developed on that. However, and this is where you start to suspect that something, all wasn't well among the community institutions. There clearly was no agreement about how to proceed on this, because even though the Danish proposal was moving forward and there seemed to be broad agreement in respect of that Danish proposal, out of the blue, the European Commission in March 2001 introduced its first draft PECL directive. So you had one initiative running under the third pillar at the intergovernmental level, and just when agreement was practically reached on that, bang, the European Commission landed with a directive based on the EC Treaty. And it was based on Article 175, the power to make environmental legislation that we know under the Environment Chapter or title. And it was based on the requirement of the need to enhance the effectiveness of EC environmental law. So it was tied to existing community law, and its objective was to strengthen compliance and enhance the effectiveness of that law. It was stricter than either the convention or the framework decision, because it included there were no options and no derogations, etc. within it. It was rather stricter and more prescriptive. Now, obviously, a community directive adopted on the basis of community law could be done on the basis, or adopted on the basis of qualified majority voting within the council. You don't need to have unanimity. You don't need to have every state agreeing. This could be imposed on a minority of states. And probably the key thing, the key reason for the Commission to be so keen to introduce the measure at this level was for its enforcement. That effectively, a directive, as we know, at least in theory, can be enforced. There are the procedures and the mechanisms within the treaty, principally Articles 226 and 228 of the EC Treaty. So this measure was introduced. The council, representing the member states' interests, did not react at all well. They refused to approve the directive, and interestingly, the council representing the member states, contrary to its own legal advice, the council rejected the legal basis of the directive, saying that, in their opinion, that the directive could not be based on Article 175. And they then introduced, they rejected it and they refused to participate. The Commission went off and introduced then a revised first draft PCL directive in 2002, trying to address some of the Council's concerns, though I'm not sure that was ever going to be, what they did was ever going to be adequate. And then in 2003, the Council introduced and adopted a Council framework decision, so one of these intergovernmental measures, based on an international agreement, effectively, between the states in the Council. This was decision 2003-80, Justice and Home Affairs on PECL. Now that, of course, really set the cat among the pigeons, and that led to the Commission challenging the legal basis of the framework decision in the European Court of Justice, and they took an annulment action on the basis of Article 35(6) of the Treaty on European Union. So they challenged the legal basis under European Union law, and sometimes that distinction is a little bit confused. But under European Union law as opposed to community law, they challenged the legal basis under Union law. Again, back to this Article 47, because they claimed that the Council had encroached on the functions, if you like, on the competence of the EC Treaty. This led to the famous environmental crimes case, and in 2005, the court handed down a landmark decision in this area. They said that much of the framework decision, the intergovernmental third pillar framework decision, did encroach upon EC law and was therefore invalid, contrary to Article 47. What the court basically said in this case was that if that the community institutions could adopt criminal measures, particularly harmonising measures, harmonising national criminal law, if the measure was essential, if it was essential to effectively achieving policy objectives, and in this case the objectives of environmental protection under the EC Treaty. Now, that was all they said, really. What they were unclear about was what kinds of measures could be adopted at the community level. And the Commission misinterpreted the decision. They issued a communication shortly after the decision saying that this appeared to give the community institutions the power to adopt criminal measures, defining or identifying what conduct would constitute criminal offences, if you like, defining criminal offences, and also setting penalties. Now, the Commission did this despite the fact that the Advocate General's opinion in the case actually suggested that the EC Treaty did not provide competence to set penalties. Did not give competence, legislative power, to legislate for the type and level of sanctions. And the Commission really sort of ignored the Court didn't deal with it. The Commission ignored the Advocate General's dicta on this and went ahead. And they, in 2007, they introduced or published the second draft PCL directive. And the second draft PCL directive is still a very interesting instrument because I think we're going to see it in another form, and I'll explain that in a moment as well. But it, as well as defining the defences, it also sets down penalties, and it creates this 3 levels of seriousness of offence, if you like. There are 3 levels, and then 3 levels of corresponding sanction. And there are those 3 levels for both offences committed by natural persons and offences committed by legal persons, for which we can really largely corresponds to corporations or companies. Obviously, they were maximum penal sentences for natural persons and well, thresholds, maximum, minimum fines then for companies. However, in October 2007, the ECJ handed down its decision in the ship source pollution case. And the ship source pollution case was a challenge to the validity of another third pillar measure. Again, what had happened here was that the institutions had fallen into this habit of adopting double text packages of measures, where you would, in very broad terms, outline what might constitute an offence in a directive, but then in a framework decision set out what the penalties might be. And the Commission overreached themselves a little bit by saying, no, we'll put it all into a directive, it's all part of community law. And in the Commission's challenge to the legal basis for the ship source pollution framework decision, the Court made it very, very clear that the type and level of offences falls within the scope of the third pillar. So where does that leave us? What we basically have is we've got 2 different pieces of legislative competence under 2 completely different legal frameworks. The European Community in a directive can define environmental offences. The European Union under a Council Framework Directive can set the type and level of penalties or sanctions. Hardly a very satisfactory situation. So the 2008 PCL directive was actually adopted on that basis in November 2008. It was adopted on that basis, and so it's a fairly thin instrument. It just basically sets out the nature of the defines the activity. That in itself is a little bit interesting. Further case law has also clarified to some degree what the community can do in legislating for environmental crime, or any crime. In the Intertanko case, which involved a legal challenge to the validity of the ship source pollution directive, again that double package, this time it was the directive, and it was it was a referral by a challenge to its validity by a group of tanker owners, Intertanko, and they challenged it on the grounds of legal certainty. And their principal argument was that such concepts in a community measure, such as intent, recklessness, serious negligence, that these were not sufficiently certain, and that therefore you didn't have the law, you were creating an offence without adequate law to support that offence. But the Court refused. The Court found that the terminology, much of which of course exists in the PCL directive, that this terminology was perfectly fine. What they said was that no comprehensive definition of these terms was in fact possible. But they reminded they pointed out that the measure as a directive would have to be transposed, that each of these concepts, serious, negligence, intent, were all perfectly well understood in the law of all member states. And that as member states had responsibility for transposing the directive, they would make sense of these terms as they transposed. So that at least tells us that the PCL directive wouldn't fail on grounds of uncertainty. What are the offences? Well, very simply, Article 3 states that conduct when unlawful, and we'll come back to that, conduct when unlawful and committed intentionally or with serious negligence, at least these ideas are fine after the Intertanko decision, that basically member states must ensure that these activities constitute offences. Now, the particular conduct when unlawful includes the discharge. I've summarised these down, but the discharge or emission into air, soil or water, etc. Air is covered in this one, causing death, serious injury or substantial damage to the environment. Any waste management operations causing, again, death, serious injury, substantial damage to the environment. Shipment of waste, a big area in terms of environmental crime, by the way. Operation of dangerous plant causing death, serious injury, blah, blah, blah. The management of nuclear materials causing all of those things. The destruction, taking or trading of protected fauna or flora. Conduct causing a deterioration of a protected habitat, and the production, import, export, marketing, etc. of ozone-depleting substances. Now, as we'll see when we look at this idea of unlawful, I mean, unlawful basically means if it involves a breach of a broad a long list of community measures, of substantive, sectoral, community environmental law. And we'll look at what these are in a moment. And these are all listed in Annex A, and also then legislation adopted under Euratom in relation to nuclear materials in Annex B. Or breach of member state rules which transpose and give effect to the directives listed, the directives and regulations, the community measures listed in Annex A. Now, this tells us something, really. I mean, this starts to look a little bit familiar. It starts to look a little bit like the Environmental Liability Directive, where we have this the Annex 3 in the Environmental Liability Directive. And it tells us, really, that as required by the ECJ, this is primarily a measure concerned with the enforcement of EC environmental law. It's about trying to ensure effective and improved compliance with community environmental law. I think in that way, we can look at it in conjunction with the Environmental Liability Directive, that the Environmental Liability Directive and the PECL Directive are really, milestones in a community campaign, if you like, to strengthen compliance. A number of things make this perfectly clear anyway. I mean, for example, if we look at the definition of protected fauna and flora and the scope of these ideas and of protected habitats, this corresponds, really, really, really very, very closely and refers to the Wild Birds Directive, the Habitats Directive, etc. So it's really just about effectively ensuring effective compliance with these measures. Also, one of the things we see is that compared to the second PECL directive, the directive as adopted removes any autonomous offences. There was an autonomous offence included in the second draft, but in the final directive as adopted, every offence here must involve a breach of community law, not just some kind of offending conduct in its own right. It must involve a breach.
5 minutes on.
Sure. The offences continued, these include inciting, aiding and abetting under Article 4. Article 6 deals with liability of legal or corporate persons, and this includes where a lack of supervision or control by a natural person, so where a living, breathing person fails to exercise effective supervision or control, and where this is then operates for the benefit of the legal person, etc. However, the corporate offence, well, they need not be offences. Criminal law need not apply. It's entirely up to the member states. Need not apply to corporate offending behaviour. And this would appear to simply be recognising the divergences and the difficulties in member state legal systems of actually imposing criminal liability on corporate entities. But that's left out. However, it's at odds with Recital 3 of the directive, which talks about, very briefly, that compliance can and should be strengthened by the availability of criminal penalties which demonstrate a social disapproval of a qualitatively different nature. Why should that social disapproval not be expressed in relation to corporate behaviour? It leaves a few issues. Again, Recital 15 basically allows for this list to be amended on an ongoing basis. To quote, whenever subsequent legislation on environmental matters is adopted, it should specify where appropriate that this directive will apply, where necessary Article 3 should be amended, etc. Annex A, infringements of 69 community legislative instruments on waste management, water pollution, air pollution, nature conservation, dangerous substances, use and deliberate release of GMOs. I've reproduced them in the paper, all 69. I found that if any of you ever have any problem sleeping, sit down and decide that you'll include 69 community directives with citations. It works a treat. Penalties. And this is where the whole thing falls down. The community doesn't have the legislative power, as we know from the ship source pollution case, to actually include penalties. So you can create a common list of environmental offences, but not create common penalties. Article 5, for natural persons, it says that the member states must introduce effective, proportionate and dissuasive criminal penalties. This obviously contrasts with the second PCL directive, which set down these 3 levels for both natural persons and corporate persons. Article 7 then, for legal persons, effective, proportionate and dissuasive penalties, not effective, proportionate, dissuasive criminal penalties, so you don't necessarily have to impose criminal liability. The problem is there is no reference in the PCL directive to any third pillar framework, existing or planned. So it's clear that this measure, to be fully formed, requires a corresponding framework decision. But there's no reference to it, and whether or not one will come along, we really don't know. If it does, I very strongly suspect it will look very much like the second, or the relevant provisions of the second draft, which had these 3 levels of seriousness and 3 levels of offences for natural and corporate persons, or legal persons. Now, finally, the Lisbon Treaty amendments. The Lisbon Treaty, if it is eventually adopted, would make very significant changes in this area. It would introduce it would make very significant amendments to the EU legal framework generally. There'd be no more EC, you'd just have the Union. But it would include express procedures to harmonise national criminal law. And these would be contained in Article 83 of the proposed TFEU, the Treaty on the Functioning of the European Union, the new treaty. This would be Article 83 of Chapter 4 on Judicial Cooperation in Criminal Matters of Title 5, Area of Freedom, Security and Justice. Now, interestingly, Article 296 of the TFEU prevents the use of Article 192 of the TFEU. 192 would be the new 175. It would be the environmental lawmaking provision of the new treaty, if adopted. With 2 key powers. Article 83.1 it covers particularly serious crime with a cross-border dimension. It doesn't mention environmental crime specifically, but that list may be expanded by the Council acting unanimously, etc. Anyway, there's no real need to worry about 83.1, because why would you use it when you've got 83.2? 83.2 provides the power to adopt minimum rules on offences and sanctions if these are essential, or if there is an essential need in respect of policy implementation to achieve the objectives of an area of policy like environmental protection. I won't read it out to you, it's in the paper, 83. Now, it also includes a number of both of these. Article 83.3 provides a number of safeguards for national sovereignty if either 83.1 or 83.2 are used. And these will include, usually these measures would be adopted on the basis, or these would be used, and measures adopted under these on the basis of qualified majority voting. But you have an emergency brake procedure under Article 83.3 where if a member state feels that the adoption of criminal measures would affect fundamental aspects of its criminal justice system, then what they can do is they can use this emergency brake procedure under Article 83.3. The whole thing will be stopped, it will be suspended, and if agreement cannot be reached in 4 months, it will not be adopted, it will die. The only thing is that if 9 member states or more, a minimum of 9 member states, if they agree to go ahead with it, then they may on their own go ahead with it on the basis of enhanced cooperation. So you would end up with a core of a minimum of 9 states going forward to adopt the measure. There's more power for national parliaments in respect of if a majority of national parliaments issued these reasoned opinions to the effect that the measure offends the principle of subsidiarity, then the thing gets really quite complex. I won't go into it too much, but the Commission must justify the measure, the Council and the Parliament must review it and then vote on it. If 55% of the votes in the Council or a majority of the votes in the Parliament reject it, then it's dead. And then there's the Irish, UK and Danish opt-in in respect of Title 5 of the TFEU, which is just carried over from as a Title 4 of the EC Treaty. So Ireland would have to give notification of its wish to participate in the adoption of any such measure. Conclusions, the current arrangements in relation to double text packages of measures is very cumbersome. The the scope for inconsistencies and the scope for anomalies is immense. Currently what you have, for example, is you have a directive adopted on the basis of qualified majority voting, which only identifies what's a crime. We don't have a corresponding, it's the fact that we need one itself is peculiar, but we don't have a corresponding framework decision. I mean, if you have qualified majority voting for one measure, well then a state that's outvoted simply has to dig their heels in respect of the second measure, and the first measure remains largely meaningless because there are no minimum sanctions. So it's full of anomalies. The implied powers basis is problematic as well. The Lisbon amendments would provide a more coherent legislative basis, and they have these additional national safeguards. And then finally, I mean, it's not quite clear what the impact would be on Irish law. I mean, if you take a look at I know there were some copies available this morning at the report prepared by the Working Group on Environmental Law of the Law Society of Ireland, published last year. A table was produced of environmental offences. At the back of that, we have an awful lot of environmental offences. An awful lot of the offending activity would probably be caught by environmental offences in Ireland. Whether the penalties would correspond, with any penalties eventually introduced by a framework directive or under the amended framework after Lisbon, who can say it? Take sort of careful scrutiny of each of these. Sorry for taking so much time.